Good afternoon, everybody. Today is September 24th, and the Board of Commissioners Workshop meeting is called to order at 2 p.m. Will City Clerk please call the roll?
Mayor Black.
Present.
Vice Mayor Hodges.
Here.
Commissioner Andrews.
Here.
Commissioner Douthat.
Present.
First thing on the agenda is public comment. So the floor is now open for public comment on anything related to city business, but not on the agenda. Once those items come up on the agenda, you may have your comments then. Time is limited to 3 minutes, and I ask that you be civil and respectful. And remember, please just speak directly into the microphone, state your full name and address. Thank you. Public comments now closed. First item, or the next item, is Ordinance 2019-07. City Clerk?
Madam Mayor, the heading doesn't get read in the workshop, but I did want to say that Kurt had made some grammatical corrections to the ordinance, so what you have in front of you is the revised one.
Starting.
For the record, Jerry Murphy. So the ordinance that you have in front of you is the ordinance that you considered most recently for first hearing and directed it to this workshop for reconsideration. We have cleaned up or tried to clean up the language to some extent throughout the entire aspect of the ordinance. And that's probably the best way to look at these things as we open them up to clean them up. I think that one of the major considerations, and I was just trying to find it, was the height limitation. There seemed to be some divergence of opinion whether it should be 5 or 6 feet. I'm going to recommend to you that it be 6 floors, 6 stories, because you have projects currently now that have been approved under that notion, and to change that to 5 stories would make those projects non-conforming, which is problematic for future development and for those projects as well. It doesn't mean that you would have to approve something that was 6 stories that came before you as a request, but it would help to legitimize these projects that are already being built. That's the major consideration that I have, but obviously this is your workshop, so if you have any questions, I'm happy to try and answer them.
Mr. Murphy, I have a question. I've asked before, and I just want to clarify it again, especially since we've changed some of the wording here. When it says 6 floors, now is that 6 floors over parking, or would you count the parking? I know I've asked the question several times, but I just want to verify one more time.
Yeah, that would be a policy decision for this board, but as I read the ordinance, that would be 6 floors total, including any parking.
So it would include parking?
Yes, ma'am.
Okay, thank you.
And that would be measured from base flood elevation, so that first floor of parking is likely not to be counted because base flood elevation is quite high on the barrier island. And because the Florida Building Code now requires 2 feet of freeboard, that would also be included in addition.
Okay, thank you.
Yes, ma'am.
So does that mean it would be 7 stories, actually?
Well, if you
In
count
theory.
that floor below base flood elevation, but those don't really count because that's supposed to accommodate water in a flooding situation, hurricane situation. But it would be above grade.
Can you explain, excuse me, what massing means and specifically intensity in terms of development?
Massing is a planning term for the configuration of the mass of buildings, the 3-dimensional envelope that a building occupies. The idea being that, you know, if you want massing to be compatible, you don't want to have a 1-story building next to a 20-story building. That's a bad idea of massing. Within a larger project, like the project that's being developed around Madeira Way, you know, the idea is that the massing would be similar, that there wouldn't be, again, a small building and large buildings. You try and keep that all proportionate.
What about intensity?
Intensity is generally a measure of the use. So let me think of a good example. A 7-Eleven convenience store has a more intense commercial aspect than does, say, a real estate office.
Okay.
And it's also a measure of square footage with regard to commercial and sometimes residential use. You know, the more square feet, the more intense. But generally, it's referred to use in terms of the impact that the use would cause.
Well, I would also like to remind everybody, I think I mentioned this last time we discussed this, that at the 11/27/18 workshop, the board all said, we don't want anything over 5 stories. And I think by that we meant we were including the BFE.
So 5 stories above BFE.
No,
To include.
including,
So 5 stories above grade.
yes.
So that would be 4 stories above BFE in most instances.
So, I mean, if that's what we've asked for, I don't know why it's coming back any differently.
And you can certainly make that change, and that provision is on page 5 of 147. It's section 110-386, subsection 3.
Okay?
Madam Mayor, just from my understanding, I wasn't here, but there's 3 projects that are in the pipeline that got stopped in the pipeline. And I think their criteria is 6 floors, and I guess at some point in the approval process, it was approved, and then the process stopped, from my understanding, which is the whole point of contention, and correct me if I'm wrong. So what I would prefer, if for the purposes of the ordinance, and I don't know if this can be done, but I'll let the attorneys reflect on the fact of the keeping us out of court, basically, of having some way of looking at them separately than where you would look at other projects down the road that have no expectation of or expenses out there on doing engineering plans and architecturals and everything that's been done. Can you?
You know, before you go on, let me throw one thing in there. Then this should state for these 3 projects only.
Right.
And it does not state
That's what I'm
that.
bringing up.
Yeah, that needs to be stated very clearly in there, that this is for these 3 projects and no other projects, period.
Julie Mandel, Special Land Use Council. I was going to indicate you do have ones in the pipeline that, although we had other process issues that were resolving this due to court cases, one of those process issues didn't relate to height. You did not have within the body of your ordinance at that time any limitation on height, so we would want to make sure that they have the right to be processed at the height that they're currently under process for. And if you make, you know, and as you review that, you can make what the decisions that you need to make as it relates to those projects. That being said, we would need to probably put some additional language in here to deal with the idea that those are in process, but that moving forward, those are not going to be acceptable applications. Because what I hear you saying is you don't even want to see an application that's over that height, meaning that it wouldn't be able to be processed that way. And just to step you back, one of the reasons that Ms. Portell had expressed to you that she had put in the language the way she did, one related to the projects that were in process, but also the recognition that your current zoning classifications don't really allow, I think, for much more over 3 stories. So to go through this process of a PD just to add 1 additional story, I think that's a bigger conversation as to whether or not you even want to utilize the PDs at all, if that's really all you're getting, you know, besides the other issues that you would be looking at, massing and scale and those things, which I know are planning words, but they really visually do have a part to play in your process. You know, the question of whether or not you want to have that level of a limitation informs whether or not you really want to keep the PD on the table. So we certainly could get some consensus today. I don't think you make decisions at your workshop, and this isn't in front of you for a reading to make a decision. We could get some consensus. It may require us to bring it back for a first reading hearing if there's too much change that gets to be made, or alternatively, what I may suggest is we turn it into 2 separate ordinances so that we can go forward, at least with the process changes, while bringing the other ordinance forward. And we can discuss that from a legal perspective later, but just be aware that those are some of the reasonings why it does have the 6 stories in it, and why the reasoning was for the 6 stories, and also utilizing whether or not the bigger conversation of the PD is something you want to have. Thank you.
Who stopped? You said it was stopped, the 3 projects were stopped. Who stopped the 3 projects? Was it them? Was it us? Did they just not come back because of what we were asking? Who stopped the project?
Well, the applicant was placed in the position of having to stop moving forward because of the previous lawsuit that was filed, that while resolved, there was a court determination that the way your ordinance reads today makes it a virtual impossibility for anybody to move forward into the process successfully. That was the whole premise under which we were bringing forward these changes, to make the requirements for submission requirements that can actually be achieved at this point in a project. And there were letters that were drafted to both the city and the applicant raising this exact same issue, thereby putting everybody on notice that the probability was if those projects were to move forward, they would be undergoing litigation. So we need to fix the fact that you have within the body of your ordinance what is really an impossibility to meet.
So basically, we eliminated or taken things out of out of the ordinance, so people could meet the requirements for these 3 things.
For submission, not for approval.
For submission. But we, the city, did not actually stop the project.
In essence, by not taking the action that we're taking, and that's the thing when we had our private conversations, in actuality, what we're doing is putting forth an ordinance and having a process that is, you simply can't meet. And because we're on notice of that through the previous litigation, and we're on notice of that because we've received letters, it's one of these situations where a court may be the one to decide whether or not we are the ones that stopped it, or it was the applicants that were the one that stopped it, and that's where the risk we are in right now.
Well, when the people applied for their permit or for their PD, they knew what our ordinance was. So, how do we become the bad guys in this when here's our ordinance, you need to meet this, and they still went ahead and put in for the PD and everything else to do this. So I don't understand how they can make us the bad guys if we told them up front, here's the requirements. You can't meet them, sorry about that.
I understand what you're saying, but if you recall in our conversations, our one-on-one conversations, I went through a more significant legal analysis, and I would not recommend that I get involved in so much more of a legal analysis on the record. I'm happy to do it if you would like me to, but I think we're better served not getting into that conversation on the record. I think we're better served with us understanding the reason why, from a legal perspective, we're making this recommendation. We know that there are 3 applications in the hopper that need to be dealt with, and if the ordinance just needs to be crafted in such a way that it is only applicable to those, then we can do that. The whole point of the 6 stories versus the 5 stories, however, although you have some in the hopper that applied in such a way that your previous PD ordinance did not have a height limitation, and I don't think it would be a wise idea not to let them to continue to move forward. If it is the will of the commission to not have it be 6 stories and want to lower that, then we just need to have some consensus on that and allow us to draft it in such a way that's legally defensible.
Also, reading this in 110-386, it says, in keeping with the stated intents of a comprehensive plan and furtherance of the historic and desired low-intensity character of the community. If I remember correctly, the comprehensive plan called for 3 stories.
I don't think that it was the comprehensive plan that calls for 3 stories. It's your zoning code that calls, that all of your zoning districts don't allow for consideration of anything further than 3 stories. And your Euclidean zoning districts are those zoning districts that exist, and somebody will have to correct me if I'm going too far afield of what your code says, but it's what my understanding of your code and my review of it. You have your Euclidean zoning districts, meaning the ones that say, here's your limitations that exist today, and the whole premise behind the PD when it was originally brought forward and it was placed within your comprehensive plan to have this is to allow additional flexibility both for height, massing, scale, for projects where maybe you have a developer or property owner that's willing to give some public space or to give. So it becomes really a negotiation between the city and the developer in order to meet the intent of the comprehensive plan to allow both the flexibility and for them to receive something more than exists in your standard Euclidean zoning districts. So that's kind of stepping back to the whole point of why you had a PD to begin with. And so this is just restating the idea that the intent of your comprehensive plan was to provide an opportunity for this level of flexibility. Again, doesn't mean anybody's going to get anything without going through the proper public hearing channels. But that's why we were recommending, we have been recommending these changes to at least allow people to walk in the door with their application in such a way that isn't automatically going to subject us to potential liability or a lawsuit from a third party.
A couple more questions. Mr. Murphy just kind of said, you know, you don't want to build a 20-story building here and have a 2-story building here. So with the building that's trying to be built between the 2 condos over there, they're either 7 or 8 stories.
Is that a pending application?
Yes.
I'd prefer us not to talk about specific
Well,
pending applications, but generally.
I'm just kind of saying, so if they go lower, let's say they say we only want to build a 1-story building here between 2 8-story buildings, it doesn't make sense. You know, from what Mr. Murphy said, right?
It's one of your considerations. I think that what he's saying is those are your considerations. When an application, and I know that this, in a sense, feels like the cart before the horse, because you're talking about the standards you're going to review something by without something in fact in front of you. But you need to set those standards, and that's what this is doing. The whole premise is when you get a PD that comes before you, and say for your example, you have a PD that comes before you where somebody is seeking a 1-story building with a flat roof that, you know, between 2 7-story buildings, one of your analysis may be, and it doesn't have to be, it may be, we don't think that's really in character or fits the scale of what is surrounding it, and you would have as much of a right to make that determination given the evidence by a 1-story building with somebody coming in with a 6-story building saying the same thing. So the whole point is this informs whatever your review process will be, but it doesn't obligate you to make a decision. This just gives you the guidance that you need in terms of what are the things you're looking at. And so your example of the 1-story, it's the same analysis of a 6-story building. You get to review it and look at it and determine whether or not it fits the scale, intensity, and the look of the area that it's existing in.
So you're also saying, if I'm understanding correctly, if project B or C or A, whatever one you want to say, comes in and says, you know, here's our request to do a 6-story building, and I say, no, 3 stories. And they said, no, we won't, we're going to 6 stories. And we say, no, 3 stories. And so it gets turned down. Can they sue us because the PD says we can go to 6 stories high?
If what you're doing is, say you're looking at it in the context of the surrounding area and what they've come forward with, in your opinion, based upon the evidence in front of you, doesn't meet that, then I feel incredibly comfortable that you can deny it.
So
As long as that evidence exists. The fact that you say to somebody, well, you know what, this really doesn't work, it doesn't fit the scale, it doesn't fit the area, it's too intense. We think if you bring it down to 3 stories, we'd feel much more comfortable, is the way practically every PD ends up going. I mean, that's part of the whole process. They have a right to have their denial on their 6 stories, but if you as a board, looking at all the evidence in this given situation, say, that doesn't work, that doesn't look right, it doesn't meet the character, it's too intense, But you know what would be less intense and what we would feel more comfortable with, 3 stories, then you can have that conversation with the applicant and they can make the call whether or not they want to go for it on their 6 stories, or they want to hear that you've reasoned out why you don't think it works based upon the evidence in front of you, and you're advising them that they would that it would be more comfortable in that area, given the evidence in front of you, to go to 3 stories. And that is a part of PD processes all over the state.
Who makes the decision on averaging?
You make the ultimate decision on
On
averaging.
average, okay.
Madam Mayor, if I might, just to add a caveat to what the attorney said, you can always be sued. You can have all the reasons in the world to deny 6 stories and recommend 3 stories, and they don't like that, and they can sue you. But your potential of prevailing on that lawsuit is going to be so much better if you make findings on the record of why you've determined that 6 stories is not appropriate. And that's, that's the kind of factual guidance that staff will provide in a staff report for any particular application.
And I should have said that as well. You can always be sued. But again, the question is making sure you have a record that's defendable. And that's why you have a professional staff that can advise you.
From what I'm hearing, we need this PD for these 3 pending projects. And as Commissioner Douthert said, I don't know why we can't put a stipulation in it. It is for those projects. Because we already have a plan. We already have zoning rules. So, people can build what they want. We don't need a PD, as long as it fits within the zoning.
If the consensus of the commission is to do that, we can draft that language and we can deal with that. But the question for you to really analyze is, what do you want to do going forward?
That's what I just said.
So then you really need 2 separate ordinances, one that would deal with the projects that have been applied for, and a separate ordinance that would either do one of 2 things: relieve yourselves of a PD. And I don't know if that's possible under your comprehensive plan. That's a bigger analysis, and I haven't done that analysis, and that would be for Mr. Murphy to look at and determine whether or not that there's some obligation in the comprehensive plan. And I'm not saying there is, I'm just saying I don't have the answer to that question. But then also for you to recognize that at that moment in time, you're making a policy decision, and you just need to be confident and comfortable with that policy decision. So what I would recommend, I think, notwithstanding my recommendation, I think we really need to get some consensus on that particular issue, on whether or not you only want this ordinance to be for projects which have previously been submitted, or whether or not you want to just put this in the code as is and then come back and make a different decision on what you want to do with your PD process.
Well, let me ask a quick question. My position's still pretty much the same as it was the other day. I don't like being sued, and I think that, the language in here that before it was corrected offered us a lot of opportunity to be sued from, just because just little things. We need this piece of paperwork, that piece of paperwork, and I would like to get that cleared up. My question is, if we've lived with this ordinance, and let me be really upfront for the record, I'm not a developer, I've got no skin in the game here, but if we've lived with an ordinance that has not limited or not even had mention of the fact of a maximum of 6 stories or a maximum of 5 stories or 3 stories or what have you, I think every developer knows by now what they can and cannot get by our planning commission, and then that comes back to us. Why did we even put this 6 stories into the ordinance now, since we'd never had it before? Why did we, we didn't change this in order to not get sued. We changed this for what reason? That doesn't keep us from getting sued, right?
So I believe, and I'll defer to the attorney, but I think the court said that you had a lack of criteria in your ordinance to make a determination. And so there was no predictability for the development community, and that your yes or no could be arbitrary, and obviously the courts don't like arbitrary decisions. Just while I've got the floor for a minute, one other thing to consider, within the community of Madeira Beach, you have buildings already that are much higher than 6 stories. And, buildings that were built in the 60s and the 70s are now 50 and 60 years old. There will be redevelopment potential down the road, and if your height limitation in any process, the most flexible being the PD process, is 6 stories, that becomes problematic in the redevelopment of a 10-story building. Just the redevelopment of a 10-story building, because they're generally in condominium ownership, getting that together is a real challenge, and Barrier Island communities across the state who have done a down zoning, so to speak, with regard to height limitations, are now confronting the problems of properties needing to redevelop. Sometimes they burn down. Properties needing to redevelop and not having a way to do that. So I think that the 6-story going forward is kind of a good compromise. It may not be something that addresses those even larger buildings down the road. We don't have to deal with that today. But I think you need to have that kind of flexibility in terms of going forward. And, I think what Ms. Mandel has suggested in terms of applications received after September 1st, 2019 or something, or under a different standard, we can craft something in that regard if your desire is to limit things to 4 stories. But for a larger perspective going forward, and I hope to be going forward with you all for a while, it's something that we need to look at in terms of future redevelopment for those existing structures that are well above 6 stories.
Right, so, I mean, and just wouldn't the redevelopment of an 11-story building, and we put a requirement on it that can only be 4, right? If we were 4 or 5, I mean, we're gonna take a huge hit on our tax base. There's a lot of things that go into something like that. So why don't we judge, that's why you kind of don't like the limit to a maximum of 6 stories. I don't think anybody's, I know I'm not, in favor of 25-story buildings, and I don't think any board that comes up here is ever going to want to pass something like that. My point is, shouldn't we judge each applicant on what they're bringing to the table? I doubt anybody at this particular point in time is going to bring a 20-story project to Madeira Beach. It ain't going to happen because they know what they're up against, and they know that we're trying to downsize anyway. But we do have 11-story buildings, we do have 7-story buildings, we do have other size-story buildings. So why even put this? I guess that's my question.
Yeah.
Is this going to keep us out of court by putting this, or can we knock that whole line out of there?
Historically, for the last few months that I was involved in this, there were 2 issues that were going on at the same time. One was dealing with the application standards, which were dealt with under a court decision, and this addresses that issue. So that was the first premise behind bringing this ordinance forward. When this ordinance was going forward, Linda Portel, when she had been workshopping other PD issues with I think even previous boards, the issue of height came up. And so in analyzing that issue, she looked at, from a planning perspective, looked at what was going on in the city as it exists today, and secondarily, some of the applications that had come in, and basically put in place a process which would limit to 6 stories because of previous directions that she had received. The 6 stories doesn't have to be in here to deal with the court case issue. That was a secondary issue. So if you choose to take that out, that's completely fine from that perspective. It really was there for another purpose. In order to deal with other commentary coming from the board. So you can, that's why I think what we really do need is some consensus, both on moving forward with the changes as they are, and also as to whether or not moving from the 6 stories, to 4 stories. But I think Mr. Murphy does, and that's why I'm encouraging you and Mr. Murphy is making a really good point, if you want to go the direction of even limiting height further, I think that's a really much bigger conversation that I would encourage you to take on as a separate process so that you can think through what that might mean. Without analyzing it, I don't know if that's from a legal perspective going to create nonconformities. We don't know what that's going to mean for some of these existing buildings. it might not mean anything, but without that information in front of you, I don't think, you can make that informed decision. And I think that's incredibly important as you make these types of decisions. So what we're really looking for then on the height issue, because I'm sensing there's some consensus on moving forward with the rest of the ordinance, even if it's just limiting it to those applications that exist. And so I'd rather separate that part of it out, because from a legal perspective, that is probably the biggest issue in front of you. And then consensus on what you want to do on the height, and then you can move that forward. And then, like I said, I would really encourage you to give Mr. Murphy a chance to analyze that height issue as it relates to existing structures and other issues in the comprehensive plan. We just don't have that in front of you, and I would hate to have you make a rash decision without all of that information, and would probably recommend you want to have that as another workshop.
Well, I think we'll open this up for public comment at this
I
time.
got a couple more things first.
Pardon me?
I have a few more things I would like to ask before that.
Okay.
In there, you talk about, if they give something, then we can give them another floor, but it's not really defined. If you put up a palm tree, you get another floor. You have to put up 100 palm trees. I mean, we're not defining things in here as to what is meant. It's like, hey, if you do a setback of a foot, does that give you another floor, or do you have to go back 10 feet to get another floor? I mean, I think things like that need to be clearly defined in this ordinance. And the second thing that I would like to ask, and I don't know if we can do this or not, right now, if somebody's going to build something, it's supposed to be, talk to the community within 300 feet of that project. Being such a small island, and we're seeing right now what the traffic congestion in with working on the road and closing Madeira Way and stuff like this. Can we make it for feedback from the whole Madeira Beach community, not just the 300 feet when a project like this comes about, or any project, comes about? I mean, it's just too massive to just narrow it down to people within 300 feet or residents within a very confined area, but it's affecting people that live on Crystal Isle way in the back, as well as a person that's living right next to Madeira Way. I guess is that possible to do that?
That issue, I recall, came up right as I was first starting to work with you all on some other matters about notice. The thing about setting forth a distance for notice, everybody would have any right to be able to come to a meeting here and give their opinion, or even to some of these other open public hearings. The problem with you defining your notice area as broad as your entire city, from a legal perspective, when you define who's an effective party, there are some limitations on that. Who technically, under our general legal standard, is an effective party, there has to be within some proximity to the project. I think you would probably create a problem if you over-define what it means to be an affected party by saying your entire city. The only thing that you could, however, do, and I know that there's a mailed notice requirement. I'm sure there's a posting of the notice requirement, and if there's not, what you might want to do is have the property posted so those people who don't receive the actual notice but can at least be aware that the community meeting is happening, you can utilize posted notice in order to deal with that. That's what most communities do. They have a limited area where you have mailed notice, and then they have posting of property for anybody who might just be an interested party but not a, quote, affected party. And I know it sounds like a legal nuance, but it actually does have meaning down the road that you have to be somewhat careful of.
I know when you talk with the 300 feet or whatever the distance is, that's called an affected party. And when they come before us, they have a longer time to talk than the average person who is not within that 300 feet.
And there's legal due process reasons for that.
And I was trying to open that up to even broader, for the people, because like I said, we're being so small. Like when they do Madeira Way or they build something on Gulf Boulevard, everybody in the city is affected, period. They are. There's no doubt about it. The traffic and everything else.
Under a legal analysis, it's whether or not you're interested or affected. You're right, everybody's affected. In a regular concept of affected, but there's a legal, there's a legal premise of being an affected party. And, I mean, 300 feet in your jurisdiction is actually quite large. So, I mean, I would be reluctant to advise you to go much further than that.
I agree with Commissioner Douthat, though. And I
I'm
don't-
sorry?
I agree with Commissioner Douthat, because I was actually thinking about that today. The city is not that big, and why can't we? You haven't explained why we can't.
Because you're creating a legal status for somebody that I think down the line might create a problem. Because you're not telling anybody they can't attend the meeting, you're not telling people that they can't give their opinion, you're not telling people that they can't give competent, substantial evidence. What you're doing is creating a legal status for somebody that's much larger than I think a court would find acceptable. And that's where I get concerned. And we did discuss this, I think, I want April, either March or April, and I raised the same issue. Now, again, it's one of these situations where if you want further discussion on that, I think we probably need to set that for a separate workshop. I'm happy to provide any kind of legal memorandum that you would want on something like that. It's just, I think that issue that you're raising about creating that status is another conversation. But I want to make it clear on the record to y'all, to anybody who's listening, anytime there's a public meeting, anybody who wants to be able to attend that public meeting should be given the right to attend. If they're not, I have the other concerns. But the secondary part of that, they should be given a right to speak.
Okay, thank you.
Madam Mayor, if I may, just to add on a little bit, the provision we're talking about is section 110-392, and at the very end of that first paragraph notification, subsection 1, there's a provision that allows the city manager to require additional properties to be given notice if that's desirable. And in this era of technology, you know, the ability for the city to post on its website plan development, neighborhood meetings is also an option that you can consider without having to change the number of feet by which someone gets mailed notice.
Okay. Well, I do know, like, when the first property came up for review before I was even elected, nobody was notified because it was a 200 feet radius and there was nobody lived there. Even though I personally lived right in front of the place that was going to be built, I wasn't invited. But the word got out, and this place was mobbed because all over the city, people were concerned because it's their city. So I would like to bring that up again and see if we can talk about that further.
Madam Mayor, I think that's a great idea. I think for the purposes of this, to try to come to a consensus, I think the best idea for us right now, I think getting this language approved to prevent any possible lawsuits, especially with the 3 projects in place right now. I think we approve the language, but I do think, you know, and I'm willing to work with you guys either way you want to do this. My opinion would be we're not going to agree on height today. I don't think that that's even possible, but I do suggest let's just strike it out. Strike out the limitations, because nobody's going to agree whether it's 4, 6, 8, or 2 at this particular point in time. But let's take that out. Let's have a town hall. Let's discuss this thing, and then we can always change this ordinance going forward. What I'm thinking is, let's get the language correct so that we don't get sued with the other requirements in this, and we can let these guys continue on with the 3 projects that are currently in the hopper right now, and then we can judge each thing on a you know, case-by-case basis up until that point. I think that's probably the easiest way we're going to get consensus on this. So let me repeat it. Basically, let's strike the limitation because we've never had one before, and let's approve the language as is, and then let's set a town hall meeting. I don't care if we do it in October, so that we can discuss this with the people in town. I don't think you're going to have a tough time approving what you want to get approved. You know, if you have a handful of developers in here, they may speak differently, but I think most of the people in Madeira Beach will probably agree with you, but I don't want to do this without their consensus. So, did that make any sense to anybody? Did I just ramble on too far? Let's approve the language as is and strike the limitations on it and kind of go from there.
If I can offer maybe a differing result, I guess. I think that the key thing is moving, as you mentioned, those projects that were in, hiatus, for lack of a better term. But the 3 projects, or whoever made application and couldn't move forward, that, the council's idea of maybe taking this ordinance, making that change, and moving this forward, so those projects can move forward. And then what other changes that come out of the town hall, which I think is a great idea, of getting everybody together and getting the feedback from the residents, notifying everybody, publishing it, and, getting that information out so everybody knows that we're doing a town hall in October, and then come back and look, for that consensus on what we can put in or leave out, or maybe not even, addressing the PD ordinance any further. Those are all decisions that you as the policymakers can make. I just want to see, I think if we show good faith that we're moving forward in reference to these projects that had already applied, I think, we're keeping ourselves out of that hot water, but still getting accomplished what Commissioner Andrews said, of getting that feedback that'll help each one of the commissioners and the mayor make a decision.
In regards to what Commissioner Andrews said was, I kind of disagree with that in a little bit. I think some stories need to be in there. I don't care if it's 6-2 or whatever, but some do. Because if we put this out and then we pass this at the second reading, the next day somebody can come in and apply under this, and they are not limited no matter what a town hall meeting says. So I think we need to have some limitations in this for right now, so we're not stuck and, somebody come in right after we do this ordinance and before we have the town hall meeting and have something at another time passed, because then we're going to be stuck with that, and they can come back and sue us on that one. Oh, we want to go 10 stories, or we want to go 2 stories, whatever the case may be. I'm just making numbers up. I understand that. But, then it puts us in the bind that we have to live with this ordinance, not with what the town hall meeting comes, because that would have to come down the road, and this would be, the people for these 3 developments could do whatever the heck they wanted. So I think it does need to at least have some type of limitation in there.
And that was my intent, and maybe it goes against what your interests were. I think you were trying to get the other resolution done before to deal with what we're going to do with the PDs. But my main interest right now is keeping us moving forward on getting these projects to an approval process. And from my understanding, this, from what Linda had said before, and correct me if I'm wrong, counselors, but the 6 stories would not impact those projects that are pending. But I wasn't here then, so I haven't reviewed it.
That is correct. The reason the 6 stories was chosen is both analyzing development within the city, but also because the applications that were pending were all at the 6 stories or below. I don't know if they're all at 6 stories. One or 2 of them may be below. I don't have the answer to that. But the 6 stories would relieve you, if you chose to keep it in there, of any concern over the existing projects. I will likely want to put some language, and I'll need to talk to your city attorney about how we do with this in order to make it clear that any projects that come in subsequent, if after you adopt this ordinance, somebody comes in with a PD, that they are somehow put on notice that there may be future changes of this ordinance that they may be subject to. And I will work with your city attorney on crafting such language. But that way we are both limiting it to those projects that are in existence, but you're not being left with a hole in terms of an ordinance and what does that mean in the, for projects coming in. Whether or not you want to keep it to the 6 stories or not and take it out, I think that's for you to decide, but I would not recommend that you go lower than 6 stories given what we know is coming forward at this point in time.
I just have one point of clarification, just so I understand what we're talking about with the 3 projects. Now, are these, I don't want to know the names of them, but are these 3 projects that have been through the Planning Commission and have been in front of the board already? Are these 3 projects that we just have applications on? Are these 3 projects that, and if they're not, how many projects do we have that are waiting to be in front of the planning commission that we haven't seen? What stage, I guess, there's my question. What stage are these 3 projects in right now?
I could tell you from what I understand, and I don't know if Jerry might have better information. From what I understand, the 3 applications that are pending are in various places. One actually did come to you at a first reading of the PD ordinance, and actually, due to a notice defect that was discovered, needed to go all the way back to the beginning. So they got pretty far into the process. I don't know the status off the top of my head with the other ones, but I know that they were far enough along that they had expended resources moving forward under the understanding that they should be able to be heard as full public hearings, not with any determination of what they have, what they would be, get approved, but at least far enough in the process that there was not an understanding that they couldn't get through until it became apparent that there was going to be a continuing problem with this previous court case.
Okay, so what you're saying is, from your understanding, anybody that is in the preliminary stages right now, that's not what we're talking about. We're talking about people that have their applications in, they've done the legwork, they've put in the proper paperwork, and they're either been in front of the planning board and been in front of us, or they're about to go in front of the planning board.
I'm going
Close
to
enough?
caveat that with, that is my
Right.
understanding.
Okay, that's all I asked.
I don't know on a
Okay.
day-over-day basis what may have been submitted,
Yeah.
but I haven't heard anything over the last few months that there's other ones that have submitted.
Okay, fair enough.
That's what my understanding.
And I can, if I may, Mayor, if I can get you that information before this comes before you all at the October 8th meeting. So I just don't have it available right now, but I'll research it and outline it for each of you.
So I just want to make sure I understand. If we go forward with this, this will allow the 3 projects to go forward as they've wanted to do. And if anything else comes before us, we have a right to say no. Well, then I think, right.
I mean, I'm sorry, I don't know if you want me to answer that. I want to just make it clear. This does not obligate you to even approve anything that's regardless of where it is in the hopper. Until you have your notice public hearing and you get the right to hear your evidence and listen to testimony, are you bound to a decision? Every case is different. My intent, if this is the consensus, is to revise this language in such a way to make that it clear that the way the ordinance reads right now is going to inform the process for the applications that are pending as of this date, which, like I said, is what I understand 3. What I need to also do, and I'm going to need to talk to your city attorney about the best approach on this, is to figure out how we deal in the interim with other applications that are submitting and what language needs to be in this ordinance, or does it need to be a separate ordinance that runs concurrent that informs how you deal with applications that haven't been submitted but are going to be submitted at some point, if any are. And so that's the only answer I can't give you, but if the consensus is to move forward to make it clear that this ordinance is to inform the 3 that are pending that we're aware of, that would be your consensus, and that's what we would bring back.
So let me just clarify that then. I apologize for beating a dead horse here, but if we approve this with the caveat that it's only for these 3 projects, what criteria do we use if somebody submits an application while this is intact?
That's why I would like the opportunity to think through how to make
Okay.
that clear.
It doesn't seem to make sense.
It is not my intent to make sure that we only apply something to 3 projects and then we're stuck with a kind of a gaping hole in your code. I need to be able to talk to your city attorney to figure out the best approach for that and managing that. I have some thoughts as I sit here, but I don't want to make something up on the fly on how we do that. And the other part, discussion is whether or not I have to bring that as a separate ordinance or not. You have already gone through first reading on this ordinance. Yes, you can make changes between first and second reading, and that was the premise of this workshop. But whether or not that's a change that, in fact, goes too far to be under the title of this ordinance, I just want to think through and speak with Mr. Brooks about. Oh, yeah, we'll, because I'll have this amended and we'll know by the 8th whether or not what we're gonna have to do to make it clear. Because if that's your consensus, I want it clear in your code so that there's no question down the line.
Well, I think we do have consensus. Okay. Well, I'll open it for public comment now.
Marilyn Halfling, 806 Bay Point Drive, and I'm just really confused as to why anybody's concerned with putting a 6-story limitation for a PD building. The citizens, for the last 2 or 3 years, we've been incredibly upset because we haven't had anything over 6 stories since the 80s, the last big condo rush. And I just don't understand why we can't agree that 6 stories should go into this, that anybody who comes here to this town knows 6 stories is their limit, and don't start playing us off with other towns and everything else. You know, we've got at least one building that's going to be over 6 coming up. And the other thing with just saying 6 stories, are you including the parking underneath, or are you just talking about the stories above that? Because then all of a sudden we have 7 stories, and I think there should be a maximum height also, because that's another thing they can play around with, is just adding other little things that stick out over the top, where the elevator is, or, you know, these decorative things, or all of a sudden you're gonna have.
Out, if I don't hear any negatives, I'll go ahead and start trying to get it planned. Do you think that's okay, Al?
Sure, yeah, I'll
Okay.
reach out to Placemaker Design.
Okay,
And
great.
I also think, well, first of all, this did fail back in May.
Okay,
And I don't recall the exact discussion in it, but I think it may have been the cost. So maybe in this meeting, we can break it down into sections. And just take, you know, one thing at a time without taking on the whole thing at once.
One thing we have to do is make sure, like, we're not dragging this out for 8, 9, 10 hours. These people have got businesses to
Right.
run. You know, it's got to be very concise and ready to go. Like, if we say it's going to start at 10, it starts at 10. And, you know, and if we have a lunch, we work in lunch and working right through that lunch, I think.
Walt, where's this money coming from? Just so, how much do we have to, just so, I mean, let's set the standard where we're saying we
I
got.
was going to come up and mention that. Right now, we have allocated for this year $106,000 John Pass improvements. Of that, $75,000 is for any type of improvements. $31,000 is earmarked for the pilings repair, but we were thinking that might come in higher. But there is a total of $106,000. And none of that has been, well, we did spend a little bit of that for the piling inspection, but the most of this money will roll over with the commission approval. And by the way, while we're mentioning that, it's my goal, probably around, probably toward the end of October, is to come to you with a list of projects, particularly capital and nature, that still have dollars that I will ask you to roll over if it's your so desire.
Okay, more discussion? That being said, we're adjourned at
I
5:01.
got one question,
the comp plan?
Yeah. Is it just to build up our muscles? Or?
We're, in case there was something we had to address, since the PD ordinance addresses the comp plan, and I thought if a question came up, you'd have it, so I just wanted to make sure you could work out. So.